Dear participants, dear friends, it is a great pleasure and an honor to welcome you to the 28th Global Digital Encounter dedicated to copyright and design renewed relationship. For this 28th Global Digital Encounter, we choose a topic which is of renewed interest due to recent court decisions in the transatlantic area and due to possible legislative evolution. The relationship between copyright and industrial designs has never been easy, has never been linear and simple. The issue of cumulative protection is, of course, one of the issues discussed. What kind of consensus exists facing new court decisions and possible legislative evolutions? What kind of consensus and what kind of unity in different parts of the world? Will there be changes pushed by national legislation or by international fora? For this very session of our Global Digital Encounters, we have the luck to have speakers from North America, from the US, from Brazil, from the UK and Italy, and from the European Union Intellectual Property Office. The objective of the discussion with our esteemed and extremely authoritative speakers is not to exhaust a very complex topic, but to think together on the designs and copyrights at a crossroad and to see which evolution at these crossroads. For this digital encounter, as this is a pro bono activity, we thank in particular our numerous friendly supporters from all over the world. We thank participants from all continents who are connected today in order to understand better on this topic. In the first part of the digital encounter, as per our tradition, our speakers will comment on the questions from our moderator. In the second part of the digital encounter, feel free to raise as many questions as you want. We want you active. The activity is made for you. This is our last global digital encounter before summer break. We wish you an enjoyable, active and dynamic encounter with our extremely authoritative and esteemed speakers. Thank you.
Thank you, Laurent, for your candid presentation and also for inviting me to moderate this encounter, in which I will express purely personal opinion in which in no way bind the institution to which I belong. Having made this compulsory disclaimer, I can say now welcome to this conversation, because it will be a conversation on the complex but also fascinating relationship between copyright and design law. And what makes this encounter especially interesting is the different perspectives we have today on that interplay and challenges, represented by panelists coming from various geographic areas and also various backgrounds. Well, to bring the subject into focus, as you know, in the European Union, the relationship between design and copyright law has always been, let's say, IP hot topic. And today is more topical than ever as a consequence of the ongoing reform of the EU legislation on design protection, the so-called design package, which must also take into account that over the last 12 years, the Court of Justice of the European Union, in some landmark cases such as Cofemel, Brompton, Floss, confirmed the possibility of dual protection for designs of applied art, both under copyright and design law. So currently, at least in the European Union, design of functional objects such as a lamp, furniture, etc., can be protected both by copyright and design law, leading to some practical consequences due to the different protection period, and also, let's say, to some uncertainty due to the fact that the expiration of design rights on an object does not automatically guarantee that that design can be freely used because copyright can exist still on that object. In other jurisdictions, the situation is completely different. For example, as far as I know, the Australian law has recently and comprehensively regulated, codified the conflict between design and copyright, setting out provision that, for instance, exclude the copyright infringement where there is a corresponding design register. And I'm sure that our panelists will give us very valuable information concerning the situation in other jurisdictions, such as the United States. For instance, we have David there, or the United Kingdom, we have Enrico, and Brazil, where Ingrid comes from. So in view of the short time at our disposal, I will suggest to focus on 3 interrelated questions before turning to the audience. The first one will be the adjustment of the principle of cumulation I've just mentioned. The second one will be the consequences of the landmark judgments such as COFEMEL or Brompton. And the third one will be the, let's say, intricate relationship between the originality requirement and copyright protection for the science of applied arts. So I just like to reiterate the invitation to the audience to actively participate. Please share your insight and pose questions to our panelists, because only in this way we could have a comprehensive understanding of this critical topics. So without any further preamble, because we have a time constraint, let's embark on this journey. And I'd like to start by asking Enrico to give us his view on how we can adjust this principle of accumulation. Enrico, the floor is yours.
Thanks, Sergio, for the kind presentation. I mean, adjusting the principle of accumulation. This is what basically is explicitly mentioned in the proposed regulation, not the package, the design package that Sergio just mentioned. In particular, recital 33 of such proposed regulation clearly says it is appropriate to adjust the principle of cumulation of protection under design law and copyright law. Of course, someone may say this was inevitable after COFEMEL, right? After the COFEMEL decision of 2019, which, again, let's remind, said that the subject matter protected under design law can, at the same time, be also protected as a work, as a copyrightable work, as long as it satisfied the originality requirement, the intellectual, not the intellectual creation test, our author's own intellectual creation, right? So it was kind of inevitable, probably, because I mean, let's remember, before COFEMEL, so before 2019, it was rather unclear whether the EU member states could independently, autonomously determine the, preconditions of cumulative copyright protection for design. There was this Article 17 of the Design Directive, and also another provision of the regulation, design regulation, which seemed to give, to demark different competences. I'm gonna just remind what this provision said. A design protected by a community protected by a community right shall also be eligible for copyright protection, and the extent and the conditions of this protection shall be determined by each member state, right? Well, now with this new proposal, which was set forth in November, at the end of November 2022, so a few months ago, there is this proposed adjustment. If we look at this new article in the design regulation, Article 96 it says a design protected as EU design shall also be eligible for copyright, provided that the requirements for EU copyrights are met. So the competence of national member states disappears here. The reference to the national member states, it seems that just, if the work of applied art satisfies the intellectual creation test, should be protected by copyright as well. No, this is the adjustment enshrined in the new package of December 22, the proposal. We could say that this is a kind of ex post approval of COFEMEL. Probably yes. it seems that we want to, let's say, ratify in positive law what the Court of Justice said in Coffemel, right? If I have just a few more seconds, I can, Sergio, I can about, probably there is an unintended consequence of this adjustment, probably, and it has to do with exceptions to design law, especially the spare parts exception, the so-called must match exception in design law. Just to define it, it was already in the previous, in the previous directive, I mean the regulation, design regulation, but the new design package entails a broader repair clause, not to kind of liberalize more significantly the spare parts market, especially for cars. No, there is a big competition between original car manufacturers and independent spare part. So, but this broader exception, which is contained in the package, might be watered down. A further
element of friction with the copyright law.
Because if you say that spare parts may be eligible for copyright, this expansion of copyright might undermine or make meaningless the broader spare part exception under design law. So we will see how it will play out. Also, it will depend on whether this spare part might be eligible for copyright protection. But I mean, there is no artistic element required. So this might be an unintended consequence.
That's a very interesting point. I would like you to elaborate further on this in the second part, talking about the consequences of Coffemel and Brompton. Now, I'd like to also to have the feeling from the other side of the Atlantic. So I would ask David to let us know how they deal with this overlap between copyright design in the US.
Thank you, Sergio. Well, the Atlantic Ocean is very broad, and therefore it has blocked off Coffemel and Brompton largely from being even studied here in the United States. So let's talk about the very different scheme that we have. Copyright protection under federal law goes back to 1791, design patent to 1842. For almost all of that period, there was a requirement to elect one or the other, but not both. During that time, formalities were required. So in order to obtain a copyright, one had to go to the Copyright Office. In order to obtain a design patent, one had to go to the Patent Office. In principle, a given design could have been protected under the one or under the other, but the proprietor had to make a choice, an election. And if the proprietor started down the path of design patent protection, that precluded copyright protection, and vice versa. So this is a doctrine that has a long pedigree. My father wrote his treatise Nimmer on Copyright 60 years ago, and I've been carrying it on since 1985. The position of the treatise has always been against the election doctrine, to say, in principle, if a work is eligible for protection under each of those schemes, there's no reason why they cannot accumulate. So that was a minority position, but eventually the Patent Office came around and came up with the same point of view. And in 1995, the Copyright Office did a study, quoted Nimmer on Copyright to say there should not be an election doctrine, and then said, we agree. So the election doctrine, as of 1995, in terms of the agencies, no longer applies. So now the question is how the courts are going to apply it. And basically the courts are in the same position of saying that there can be cumulative protection. So there are different standards for copyright and for patent, different terms of protection and results. But as of now in the United States, it is possible to obtain both of them. And for that matter, also trade dress protection, which is yet a different form of protection.
Thank you, David. From your words and Enrico's words, I see that there is a constant evolution of the relationship between copyright and design law. I mean, there used to be a mutual exclusion, and now apparently there is this accumulation. So it's constantly evolving, and let's see how far we can go with this accumulation. I don't know if Ingrid would like to add something on that from also her perspective.
Yes, Sergio, because it's interesting in Brazil because our previous law, before TRIPS, our previous law of industrial property law, the design was protected by a patent, like in the US nowadays. And then the design started to be protected in 1934, and we had 4 codes that protect a design like a patent. And nowadays we have, after TRIPS in 1996, we have a specific register by industrial design. And concerning to our copyright law, the previous law from 1973, the law was expressed to the protection about to protect the applied arts. But now, after TRIPS, 1998 is our current law. We don't have this protection anymore. We don't have this expression of in the law, but we have a non-exhaustive list. So we can interpret like different thinkings, different thoughts. So we have a lot of decisions contradictory in our courts, because we face the same problem, if it's possible or not to accumulate, because it's a non-exhaustive list, it's an open interpretations. But we know in the draft of the project of our current copyright law that the legislators didn't want to protect applied arts. So we had in the draft these reasons, because we have already protected by designs are already protected by a specific register, and it was not a patent anymore. This is my consideration.
Thank you, Ingrid. I really appreciated the different views expressed so far, because they show that there is not one single approach written in stone, and also the approach taken here in the European Union is not the only possible one. So it's always difficult to balance between copyright, design, cumulation, etc. And it's fantastic to see that the different perspective can also bring ideas here in Europe on how to balance this different interests. And now, I mean, if you have anything more to add about this first question, I would like to ask again to Enrico, if you please can show your views about the consequences of the Brompton and Kaufman judgments, and also copyright protection for works of applied arts here in the... You're muted, Enrico, sorry.
Yes, thanks, Sergio. I would like to focus on the effect, the effect of this decision, especially Kaufman in the UK, because of course UK is not anymore an EU member state, so EU law does not bind anymore the UK, and therefore one may say, look, UK courts should not follow, right, this doctrine, this approach. But we need to take into account that in the UK there is a category of copyrightable works. You know that in the UK there is a close list system of copyrightable works. No? And one of the boxes in the Copyright Act is works of artistic craftsmanship, okay, which is a very particular category, which overlaps with the category usually eligible for design protection in other jurisdictions, right? But the particularity of this is that such works of artistic craftsmanship are protected by copyright, provided that they meet some artistic merit test, right? It is a kind of exception to the general principle in copyright law, according to which artistic merit is not
no longer relevant.
It's an exception to that general rule, a rule which dates back in the US to the famous Blainstein versus Donaldson case, where at the beginning of the 20th century, Judge Holmes said that it would be a dangerous undertaking for persons trained only to the law to be themselves final judges of artistic merit. I mean, this general principle is still valid also outside the US, but with some exceptions, one of which is exactly represented by the works of artistic craftsmanship. So, of course, such a rule is evidently and clearly in contradiction with what Kofemel, the Court of Justice, said, where, the Court of Justice told us, we don't have to take into account any artistic merit. We just need to focus on the originality requirement as being the author intellectual creation test, right? And so there has been a decision in the UK after Kofemel in 2020, February 2020, where in the case Response Clothing Limited case, but here the Judge Akon, did not really engage with whether, let's say, with whether this requirement, Kofemel requirement, applies to the UK or not. It just kind of avoided the question. But I mean, as I said, the UK court cannot. I mean, they could opt not to follow this approach. It remains to be seen whether it is convenient, let's say, for UK to diverge, right, from the intellectual creation test, having in mind the single market, having in mind that designs made by UK designers might then be sold in the European Union and vice versa, both ways. So we will see how it will play out in the UK. But I think what is interesting to note is that this requirement under UK law for works of artistic craftsmanship to have an artistic level, which was what the Portuguese law required as well for works of applied art before Kofemel, right? So it's not just a UK particularity. So we find it also in other jurisdictions.
Thank you, Enrico, for sharing this. I'd like to know if also in the US or in Brazil, or you are aware of this kind of peculiarities when applying special categories of artistic craftsmanship, etc. David, you like to talk first?
Thank you. Yes. Well, Enrico accurately quoted Justice Holmes saying it would be a dangerous undertaking for persons trained only to the law to constitute themselves judges of the worth of pictorial illustrations. And then he added, outside of the narrowest and most obvious limits. So now we're into the exceptions. And
David, you're frozen.
I think we've lost David.
Yes.
Let's see if we can get him back on.
Yes, probably. Okay. Ingrid, would you like to add something?
Yes. I'd like because I'm from Brazil. I really.
Sorry, Ingrid. Okay. David is back. David, we lost you when commenting on Enrico's words.
Okay. I'm sorry. Did you hear me talk about when Justice Holmes said outside of the narrows? Okay. Yes, so we constantly find judges who are saying, I'm not going to make an aesthetic judgment, and yet sub rosa they are. And so in the US, what we say is that all works are subject to copyright as long as they have a creative spark, and it's extremely minimal. But then we have the conundrum of works of useful articles, and that has been the source of tremendous ferment. Let me just make a brief introduction to it now, and then Sergio can ask me to go in more detail. We have the US Supreme Court to resolve conflicts between regional circuits. And it usually takes 3 or 5 years for the issue to percolate upstairs. In the case of useful articles, there were 2 points of view expressed in 1978 and 1980. It took 3 decades for the court to reach that issue. And that was the case of Star Athletica, which we can get into in more detail. But let me just say that that was an appeal from the 6th Circuit. The 6th Circuit said there are 9 different tests out there to gauge their protection for a useful article. The US Supreme Court jettisoned all of those standards. And so now, as of 2017, we have new standards. But there's something that my last comment about Star Athletica is it's a terribly unusual case from the US Supreme Court in the following way. it's very often that the justices disagree among themselves. One says the legal proposition should be X, and another one says, no, it should be Y. For instance, on the international exhaustion doctrine, which we call first sale. One says it should apply internationally, another says it should not apply internationally. Okay, so they would reach a different result based on a different legal principle. The difference in Star Athletica is the majority articulated a standard. And the dissent said, even applying your standard majority, we reach the opposite result from what you would. So even after this has reached the US Supreme Court, the issue remains terribly contested and cloudy. Okay, I'll be glad to elaborate more, but let me stop there for now.
Thank you, David. Ingrid was already saying something before.
Yes, because I know that the COFEMEL judgment was criticized by the doctrine because they didn't, the court didn't detail the patterns of originality, what is original or not, what could be protected or not. They missed the opportunity to develop more these standards. But I know that after COFEMEL, France that adopted the total cumul, in the Pouillet is from France. And so it's France, the judges are more strict in their judgments after COFEMEL because they are, the burden of the proof now is the author to demonstrate that what is his originality, because everything had been protected. And I think the principe du cumul it was disvirtuated, was misused as in the past years. So I think it could be, I think it's difficult to establish these standards because what is art and what is applied art and what is the same, it's too difficult to establish this, but the court has the power to develop these standards. So, so we know that people want legal certainty in their judgments, and it's a controversial subject not only in national legislations but in European Union too.
This is actually the point, Ingrid. I mean, the more complex point, once we establish, for instance, in the European Union, that there is accumulation, design law and copyright law, and that member states cannot add the further requirements for the protection of as copyright for the sign of applied arts. The problem is, how can we assess that requirements, the originality, that spark of creativity mentioned by David? I mean, then do you have any clue about your different experience, different backgrounds, about the factors, the element we can take into account when evaluating such originality, the spark of creativity? Do you want to say something,
yes,
Ingrid, first?
Yes, because, for example, in our law, we define originality, the concept of originality in Brazilian law, but it's in the concerned to design. What's original? It's what is different from the previous objects' existence in the market. So our tradition is to compare.
It's like the novelty in design issues, etc.
Yes, because we have two requirements for protection by industrial design: novelty and originality. Novelty is an object concept, but originality we have to compare with previous objects. So the author must give a contribution to the design. It must be. Also, they use this expression to explain the personality of the author. They use the same thing, but it's more. They try to be more objective compared with other objects.
I see the more or less also in Europe, situation is more or less the same. And I don't know, Enrico, if you'd like to add anything about that.
Yes. I mean, in general, as we all know, the originality requirement is interpreted differently in the different jurisdictions. As we know, we have the intellectual creation test in the EU, in the US, the modicum level of creativity, in the UK, original and traditional, we always had the labor, skill, and judgment test. Now, with COFEMEL, I mean, after COFEMEL, what can we say? I mean, the originality test, as stressed in COFEMEL and in general in EU law, is now not flavored by subjective values, right? Such as good or bad, valuable or aesthetical. It's kind of deprived of this subjective element, right? It's a kind of, it has become a neutral, let's say, no? Originality requirement, deprived of any subjective aesthetic effect. Whether this is good or bad is not our task to say, of course, but we can witness that this. I mean, in the UK, the skill and labor and judgment, of course, may confirm the fact that what we have is not a very highly meritorious, of course, artistic element test. So we go back again to what Justice Holmes said in the US at the beginning of the 20th century, right? Judges, examiners cannot be made arbiters of artistic taste, right? Because if we open that door, we probably may legitimize conflicting decision, because a judge or an examiner might like a work of applied art and the other judge might not like. So probably also to avoid conflicting decisions, we need to depurate, we need to deprive the test, the assessment of subjectivity, of subjective elements.
I don't know. I mean, when reading copyright Brompton case, for instance, I have the feeling that the test is, sorry for saying that, probably I'm going too far, but is more or less the same as we apply in design. I mean, when we have to decide if a design deserves protection, we have to identify the essential characteristic of that goods, let's say, of applied art. And if not all the essential characteristics are dictated by functionality, then there is room for something else. This room for something else can be, let's say, creativity. And if it's the expression of the author's creativity, personality, etc., could, this is a question for you, Enrico, could be protected by copyright? Because in design will be protected. I mean, if not all the characteristics are purely functional, and there are also aesthetic consideration played a role there, then the design can be protected. And I don't know if copyright is asking for something more.
Well, after Brompton, it seems that the threshold is gone down.
Yes, it's approach. I mean,
well,
we are almost overlapping.
Whether this is desirable from a policy perspective is another thing, because that might increase litigation, right? There is no obligation of registration, as we know. No copyright comes into effect upon creation of the work. So we have exponentially a huge amount of new copyrightable works entering the arena and possibly being litigated.
Yeah, that's.
I'm not sure as to whether this should be the way forward. But of course, in this specific regard, we might have different opinions, of course. Yeah. But that's what we might witness in the future. No?
And should I now? No, I was going to volunteer to talk about what's being litigated in the United States, if that makes sense now, in terms of the issues. Our current act is the 1976 Act. So Star Athletica was interpreting the statutory language from 1976. Before then, protection extended to everything from Christmas decorations to artistic jewelry boxes to cemetery monuments. Okay, since Star Athletica, what has been the status? So Star Athletica said that the designs of a cheerleader costume, the chevrons and zigzags, those do not fall outside of copyright by virtue of the useful article doctrine. There's a further question as to whether those zigzags themselves were creative enough, and that remained undetermined by the case. But since that time, I'll give you both sides of the ledger. Since Star Athletica, the courts have found protectable a full body banana costume, and the design, something called the mannequin, which was an idealized human skeleton to which people could apply clay to learn about anatomy. I happen to represent the copyright owner in that case successfully before the 10th Circuit. Now, on the other side of the ledger, what has been denied protection since Star Athletica? Okay, there was one case that talked about a very large number 2 pencil that could hold chalk. That was held to be outside of protection because the sculpture just looked like a pencil. Another case was a quote life organizer with flaps and covers, just looked like a book. And the third case is the control panel of a dryer. So those limiting cases, those 3 were not held protectable, but just about any artistic flourish that is added to a 2-dimensional painting or a 3-dimensional sculpture would find protection under US law.
Thank you, David. We have time just for a last comment from Ingrid before giving also some minutes to the audience.
I think it's polemic, but the question is how they have the designers. Now we have this cumulation is directed to the design. The designers they have another option to register, another option for protection. They have registered design. If it's a community design, they have an option to use unregistered design. And why they want to be protected for 70 years after his death. So it's a long term, and it's not. We have to think not only to the author. I know that it's infringements, counterfeiting. But we have to face this problem. But I think the period of time, the term of protection by industrial design is sufficient and to protect. They can avoid all of this discussion and then start to think about register. And you notice that nobody registered in the European Union, in their national offices, nobody, because you have this protection by copyright. So it's difficult. I think the industrial design was created for this, to protect this applied arts, and it must be encouraged, in my opinion.
It's also true that the long term for copyright protection was thought many years ago for other situation and another world. So I really thank you for your opinion expressed so far, but let's turn now to the audience and see if there are any questions or comments. So please participate actively if possible.
Right. If anyone wants to address the panel with their cameras and microphones on, please do say so. We've got, in the meantime, a small comment by Haris Hasik. I'm sorry if I butchered your name. I did the best I could. He says Bosnia and Herzegovina have the following provision related to this topic. This was something you mentioned some time ago. Article 59 of the law on industrial designs, relation to copyright 1, a design protected by a registered industrial design in B&H may, after the expiration of the industrial design, enjoy the protection on the basis of regulations governing copyright, provided that it fulfills the condition laid down by such a law, but not for more than 25 years as of the day of filing the application for the grant of the industrial design. Any comments on that?
Enrico, would you like to start first?
But it seems to me, if I have understood correctly, that this provision is replicating what the Berne Convention says. No, no work of applied art. No, they can be protected by copyright if they comply with the requirements in that particular country. So it seems to me that there is a window open for not accumulation of protection, if I have understood correctly the content of that provision of Bosnian law.
Thank you, Enrico. We have another question from Alexander. I think it's addressed to David. What are the limits of copyright protection of 3D object in the US and other parts of the world? So, David, if you'd like to start first, and then concerning the other part of the world, if Ingrid and Enrico would like to give their opinion.
Okay. 3D object, right. Well, any sculpture, anything could be conceived of, anything in 3 dimension could be conceived as a sculptural work. The limits of protection are, it has to have some distinctive features. So just taking a pencil, that's not an original composition, and making a pencil that's 2 meters long or 100 meters long, if it has the exact shape of the pencil, is not sufficient. So I would say that any 3D dimension that is not simply comprised of basic elements would be protected under copyright. And when I say basic elements, if you have the iPad that's simply a rectangle, that's not enough. On the other hand, if there's a distinctive shape, if it's made to be a blob or a guitar or some irregular cutout, that would be protected under US law as a sculptural work.
Enrico, anything to add from the UK perspective or European perspective?
Well, yes. I mean, sculptures are 3D, right? So 3D objects. So they are explicitly mentioned in UK copyright law and in many other, copyright acts, I would say. So there is no element about that. Probably issues may arise when the 3D object has also functional elements, right? Or predominantly functional elements. As we already know, if there is just technical functionality and the person, the artist, has been dictated by totally by functional elements, there is no room for copyright protection. But on the other hand, if the useful object does have functions which go beyond the functionality element, of course they can be protected. I mean, I can also cite another American case here from the 50s, Mazzer versus Stein. It was a case about, which was cited in Star Atletica by the US Supreme Court, by the way, and it was a shape table lamp incorporating a ceramic statuette, right? So it was a very, very artistic, very beautiful work. So a normal lamp without any kind of particularity, so probably would not be eligible for copyright protection under US law because it's just functional. The lamp serves the function of, enlightening our rooms. But if the lamp is, made as an artistic statuette, and of course, in addition to being functional, it is also protected by copyright, right, David?
Right. There was a Balinese dancer in Mazzer versus Stein, so that was very stylized. But I would say that every lamp is a 3D sculpture and is eligible for protection unless it has no minimal flourishes. If it's simply a vertical, a column with a lampshade on top, then there's nothing to it. But a Balinese dancer, of course, is protected, and any distinctive shape could be protected by copyright if it is original.
Which would multiply potential for litigation, right? So how many lamps are produced and distributed? Probably 90% of these lamps are protected by copyright, with the consequence that we might have.
Right, but of course there would have to be a copy of that lamp, and if an individual did their own lamp and did not copy from a plaintiff, then there would be no liability, even if they happen to look identical.
So apart from the issue of functionality, it's not more difficult to get copyright protection 3D object than a 2-dimensional object. I mean, the creativity, if there is creativity, is 2D or 3D. I mean, there is no difference apart the issue of functionality. Ingrid, please.
Yes, in Brazil is the same. We protect not as the 3D object. We must have fill the requirements like novelty, originality, and also the 3D objects could be if it fills the requirement for distinctivity it could be also a 3D trademark. So we protect 3D trademark, maybe an object that could be an industrial design could be also a trademark. But if it's a sculpture, artistic, no, only protected by copyright.
Thank you, Ingrid. Alexander, I don't know if we have replied to your question or if you would like to elaborate further on that. Okay, Alexander said we replied. I don't know if there are more questions from the floor. Raise your hands, don't be shy.
Sergio, I'm Manuel de Santos. There is a question I see coming from Victor Suedial. Sorry for my pronunciation. It says most IP laws give protection for 15 years where drawings are submitted. If you take photograph of the design, would this bring it under copyright protection?
Photograph of the design. Interesting question.
Should I repeat it?
No, we can read it. I mean, I read that most IP laws give protection for 15 years where the drawings are submitted. So when you submit drawings, 15 years. So if you take photograph of the design, will this bring it under copyright protection?
So the issue is whether if the design protection then finishes in 15 years, can the picture, the photograph, which has, code the design, can that photograph be protected by copyright or not? I guess.
Victor, could you please elaborate further?
So is it fall in the public domain? Is it after the term of expiration? It follows in the public domain, is it?
David wanted, I think David wanted.
Yes, I would say that it is eligible for copyright protection for the full in the US 95 years or like the author plus 70 years. For instance, architectural blueprints are subject matter that can be subject to copyright protection, and they are not a useful article. They are instructions of how to produce a building, which is a useful article, but the architectural plans themselves are not, are eligible for protection. There's no problem with them being a useful article, and that protection lasts for the full term.
Coming back, thanks, David. Coming back to the issue of photographing a work fallen in the public domain, right? A design from the public. Well, this is quite a relevant issue for museums that take pictures of paintings or sculptures fall in the public domain, right? There is a big debate after the Bridgman case of 22 years ago. On the one hand, of course, one camp says, look, this is against the general principle of intellectual property law, because when a work falls in the public domain, you cannot really rely on another IP right to kind of resuscitate an IP protection, right? On the other hand, take, for example, the photograph of the Mona Lisa in the Louvre. The Louvre treats such photograph as a copyrightable work, and you need to pay to get a license to use such picture. And they say, look, it's not an iPhone picture. In order to get a good photo of the Mona Lisa, we need to transport the Mona Lisa to a studio, pay insurance. I mean, it's not a minor painting, right? So it may cost 100,000 euros to come up with a nice picture. And therefore, they want protection, right, of this. And there is a provision actually in the EU Copyright Directive of 2019, which says that such kind of, I put it simply, of course, such photographs of public domain works are protectable if they are the result of intellectual creation, the usual originality requirement as interpreted in EU law. But we need to be careful with that because we don't want to resuscitate,
Enrico, the strategy will be first, try to register it as design, then try copyright to extend, and then if it's distinctive, try to register it as a trademark.
Then we have 200 years.
Forever.
But I mean,
Forever
it's not a joke. I mean, there are companies trying to register as a trademark very famous chairs that are also, I mean, in the MoMA Museum, etc., are iconic furniture. And the typical path is when copyright finishes, try to register it as a trademark to have your rights on that object forever. Of course, different conditions, different requirements, but if you get it, it's fantastic. I mean, and this, may I link this discussion with the other question I see there from Harris? I mean, given the open definition and copyright work and abstract nature of content of rights comprising copyright, I mean, the question is, why would anyone seek protection of industrial design, like design patents, and willingly limit the protection they have under copyright? I mean, if you choose design, you are potentially limiting in time the rights conferred.
And you have to reveal to the public what the conception of your art and copyright. No,
Enrico, sorry, David was trying to say something. Sorry.
Good. These are very fruitful avenues to discuss. The United States law traditionally protected the reproduction of a work of art for the basis that Enrico stated. It cost a lot of money. There was insurance, and there was a lot of effort. The Bridgman case that Enrico mentioned comes from 1999, and in that case, a very eminent judge, Lewis Kaplan, reached the opposite result, and I think he is absolutely right. It is not intellectual labor to transport the painting, to insure it. So there could be a copyright in a reproduction if it was an unusual angle, it was lighting from down below. But if the aim of the museum is to have a slavish copy exactly the way Mona Lisa looks in the Louvre Museum, that is not the result of intellectual labor, and there should be no copyright protection in that. Now, we get to that other question of when something falls in the public domain, what does that mean? And I happen to have litigated that very issue up to the US Supreme Court in the context of trademark and copyright. So there was a case in which a copyright expired, and yet they tried to protect it by saying that anyone who uses it has to say where it came from, and if they neglect to say the original producer, that is called reverse passing off. We had the US Supreme Court reject that because in our words, that would have been mutant copyright protection. So I believe that once there's an expiration of a copyright, trademark law should not come in. On the other hand, if there was a trademark that expired, if the work was protected by copyright and it's still within the term, then I have no problem with continuing copyright protection for it.
I was just thinking about, was drinking from this. Okay, you can see the Chat Noir. Okay. Apparently, it was one of the copyright register in the US in the 20s of the last century. So apparently now it's in the public domain. I don't know if somebody is paying for putting the Chat Noir on this kind of merchandising or whatever, because apparently it's the result of the previous system David mentioned, when you were obliged to register, let's say, the copyright, if I understand correctly, it was registered before 1928, I guess, in the US. So now apparently it's the public domain, but not sure about that if somebody is trying to do something strange.
We consider black cats as very bad luck.
Okay.
If they cross the road. Well. But Sergio, may I just follow up on the very last question, because it seems to me that the participant said, why should you go for design, which is just 15 years, gives 15 protection, when you may want to rely on copyright, which is, potential, which is much longer protection. Yes, that's true. But on the other hand, the scope of protection given by design rights is wider, because you at least register design in the EU, because you are able to prevent everybody from exploiting the design, even if such design had been created independently. While in copyright law, you don't have this, right? An independent creation is not attackable, right, by the copyright owner. And also, for industries such as fashion, you don't really need 100 years of protection, right? I mean, fashion designs, they get out of fashion quite quickly, right? So you may want, look, it's better to rely on 15 years of strong protection, design protection, also against independent creation, rather than a weaker but long copyright protection.
Yes, my colleague at UCLA has written about exactly that subject, Enrico. Cal Rastiello and Chris Frigman wrote about the piracy paradox of fashion, which is that the Yves Saint Laurent does not want to have 100 years of protection. He wants to have no protection at all, because everyone will buy an Yves Saint Laurent gown, and then when the knockoffs come, everyone who wore it has to buy a new one. So it's better to have only effectively 6 months of protection to induce greater market churning.
That's absolutely interesting.
And also the burden of the proof is the person that contests the design.
That's the point.
So it's stronger.
Harris is adding that the copyright law gives extremely broad rights. Their copyright law gives extremely broad rights for copyright comparable to those of the design. But it's true that I mean, when we have a design, you are, let's say, paying for an easy enforcement of your right. I mean, you have, let's say, a certificate with a presumption of validity, at least the register design here in Europe. You don't have to show anything more than your registration certificate. You don't have to prove authorship or anything else. I mean, it's the other party that has the burden of invalidating your design. I mean, it's quite easy also to enforce through customs, etc., at least in Europe. Much easier than copyright, even on electronic commerce platforms, etc. I mean, when we have a registered design, it's very, very easy to enforce it. And I see a very long question or long comment from Harris. I don't know if Harris can directly explain this, because it's a very large question. I'm trying to read it. Okay, Harris said, great point. Thank you for addressing my question. It's a pleasure. And also Alexander is say thank you for an interesting discussion. I think now it's time. So I don't know if there are more questions, but I think it's time for the wrap up. So I'd like Manuela, I don't know if you would like to wrap up or you need something more from our side.
Thanks, Sergio. Thank you very much. You know, Sergio, having had you as a moderator of this encounter has been especially emotional for me. And you know very well what I mean. Yeah,
of course.
You were brilliant, my dear. I'm very proud of you. So what an exciting topic. As you all have highlighted, it looks like designs and copyrights interact constantly. Yeah, you have dealt with dozens of topics. Perhaps you don't realize now. Yeah, but just from recollection, recollect just from memory, the judgments of the principle of cumulation after COFEMEL, the crisis of the competence of the member states for dealing with this matter, if I understood properly. Yeah, the new ex post approval of COFEMEL, the non-intended consequences of these adjustments, for instance, when dealing with the spare parts market, and all the possible conflicts of this with the copyright law, the evolution of the election theory and the compatibility theory in the United States and also in Brazil, Ingrid, the relevance of TRIPS in all this discussion. Even David, if I remember, has introduced it also, a topic which is very dear to us also, mainly the dress protection, and how to make compatible also the dress protection, copyright and designs. Then you moved into the effects of COFML and Brompton at the national level, the effects on works on artistic crafts machines, if I remember well, yeah. The application of the intellectual iteration test, the 9 tests proposed by the US Supreme Court, the different approaches to the originality test, how this test has been deprived of subjective perceptions after COFML. Yeah, I got it here. I think it was Sergio who highlighted the room for something else that brings creativity up front in this discussion. I will stop here. Yeah, I don't want to reproduce the discussion anyway. And then you move into the discussion around the questions, and this was also very brilliant. Yeah, because you know when the attendants ask questions, they go out of our topic easily. That then it was very impressive. You have brought us to the real world of what happens day by day in these topics, and we appreciate it very much. A topic that, if I bring as a final conclusion, this is a topic that is moving again and again and again. I recollect that it was also you, Sergio, that said that here in this topic there's nothing written on a stone. Yeah. So they are Ingrid, and they are David, and they are Enrico. You were also very grateful.
Thank you.
We are very grateful to you both. Yeah, be welcome now to our Encounters family. Yeah,
Thank you very much.
I have the feeling that we could have spent another hour moving from one issue to another. And but believe me, you would be surprised recognizing the report the many questions you have brought on the table in just 1 hour. Yeah, and by the way, this time the report will be drafted by Alejandro Garcia Martinez and by Raúl Ruiz Rodriguez. So thanks to you both. You know, the Encounters report has become a precious instrument for researchers and for professionals, and the Encounters support team has already provided to you all more than around almost 30 splendid reports. Yeah, at least 27, and now the 28. Yeah. So many thanks also to all those who have attended the Encounter. We are very grateful to your fidelity towards the Encounters. Thank you. Also thanks to all those, and they are hundreds, that will listen the recorded copy in the following weeks and months. Yeah. So finally, as always, try not to forget, thanks to Alvaro and to Blanca. You know, when David looked like having a siesta for some seconds, we all entered into panic, and then you solve the problem in just 3 seconds. So thanks very much. And of course, many thanks to all of you for being here today, for being so patient, and for being so loyal to our Encounters. Take care, my dears. Join us again after the summer break. We count on you for our next Encounter. The next Encounter will be already 29th Encounter, and will take place early September. We will let you know the topic pretty soon, and we'll prepare materials and references and brilliant speakers also for you. So thanks for being with us. Enjoy the rest of the day, if it is the morning, if it is the afternoon, or if it is already the evening in Asia. Thank you for being with us, as always. See you.
Thank you. Thank you.
Bye.
See you. Bye-bye.
Thank you.
Bye.
Have a nice day. Bye.
Thank you.